Good evening. The time now is exactly 7 p.m. our time here in Nairobi. As promised, the lecture this evening is on step number 5 of the forensic investigation process. Step number 5 is touching on documents, evidence gathering, analysis, and examination. This is the main body of the forensic investigation of a financial nature. You would have appreciated the fact that the forensic investigation covers very wide fields. But when we speak about forensic investigation concerning crimes like fraud, corruption, and other financial crimes like money laundering, we talk about forensic auditing. And the greater part of evidence is documentary evidence, and considering the complexity of the crime perpetrated, this step can involve correcting documentary evidence that can cover volumes and volumes and volumes of files of documents. That is why I'm saying that this is the main body of the forensic investigation of a financial nature. I will move to the gathering of evidence. I will immediately move to the gathering of evidence. Evidence can be gathered using various techniques, such as testing of controls to gather evidence which identifies the weaknesses which allowed the fraud to be perpetrated. It can be fraud, it can be money laundering, it can be corruption. Using analytical procedures to compare trends over time, or to provide comparatives between different segments of the business. Applying computer-assisted investigation techniques, for example, to identify the timing and the location of relevant details being altered in the computer system. Discussions and interviews with the employees, and then the use of substantive tests like reconciliations, review of documents, and etc. Documentary evidence. Documentary evidence gathering must be done according to law and generally accepted investigative practice. Information that is held by other people must be obtained by court orders or subpoenas. All evidence must be well preserved so as to be admissible in a court of law, because contaminated evidence may not be admissible, or it may impede the investigation, further investigation process, like fingerprints analysis. Advantages of documentary evidence. Documentary evidence is the best since documents never lie. If a document is forged, it will tell you that it is forged. If it was forged on, say, 2nd of February 2023, that is what it will tell you. It will not give you a different story. Documents will assist in establishing intent, the most important element in forensic audit or investigation. The perpetration of crime, like fraud and corruption and even money laundering, does not happen by accident. It happens through deliberate intention. And therefore, during prosecution, the prosecution team must prove that there was deliberate intention to perpetrate the crime. And the documents will assist in this regard. Documents assist in quantifying the amount of loss. If you wanted to quantify how much has been lost, then you must get all the documents involved, and then you do the calculation so that you get the estimate amount lost. It is in order to quantify the exact amount lost due to fraud or corruption, but you can get an estimate figure by using the documents. Documents may reveal conspirators. That is another advantage, that from examination of the documents, you are most likely to get the conspirators. Documentary evidence, that is another point. Documentary evidence, especially the original documents, are readily acceptable in a court of law. Disadvantages of documentary evidence. Number one, access can be difficult for some types of documents, especially if they have been banned. It will be very difficult to get the documents as a form of evidence. And as you know, the documents are easily panned. May be judged on presentation rather than content. May be difficult to confirm authenticity or validity. Requires writing, presentation, analysis skills. Requires document examination experts. May get contaminated or destroyed. May be misplaced. Those are the disadvantages of documentary evidence. Let us now move to evidence preservation. A process must be developed for the effective preservation of a crime scene and evidence when an alleged offense has been committed or an incident has occurred. This must include that the security and integrity of a crime scene and associated information are maintained to prevent evidence from being contaminated, destroyed, lost, or altered. The evidence may be replaced also. Apart from contamination, destruction, loss, or alteration of evidence, evidence can be replaced. A crime scene for a certified forensic investigator or auditor is the place where fraud or corruption or money laundering, for that matter, is alleged to have been perpetrated. This may include a section or a department or office or a branch or even a subsidiary of an organization. It may also include a computer or a computer servers if the crime was perpetrated using computers. Evidence preservation continues. It is important to maintain the security and the integrity of a crime scene and the preservation of evidence to ensure the success of any breach action taken or the success of any prosecution for an offense. Unless it is absolutely necessary, touch nothing at a crime scene or touch using special handlers like gloves that are able to protect the fingerprints on the evidential objects at the scene. The professional forensic investigator, CFIP, must understand his or her responsibilities of responding to incidents, accountability and responsibility for the preservation of the crime scene in fraud and corruption cases must fall upon 1. The organization reporting the incident is responsible for the preservation of the crime scene in fraud and corruption cases. Number 2, the lead investigator. is also responsible for the preservation of the crime scene. Continued, what can the organization do to preserve the crime scene? Number one, log the offices where fraud is suspected to have occurred. Number two, send staff on leave or relocate them to another department or another office so that the crime scene is left untouched. You remember yesterday when we were discussing about the preparation of the suspects and witnesses lab lists, I advised that it is not good, always beneficial to the investigation for the organization to send suspected staff on leave during the continuancy of the investigation. Because if you do that, you might require them to come and answer questions and you never get them back. I gave a very practical example which happened in some organization where they sent a staff, the principal suspect on leave, and when they found that they were not making good progress in the investigation and they wanted him back to assist them retrieve some files, some information, and also give them an information fire interview, he refused to come back. He told them, no, I'm satisfied with what I've taken from the organization. And therefore, he told the messenger to go back and tell the investigators. He called them stupid investigators, but the messengers could not relate a message directly. He told him that go and tell those stupid investigators that if they are not able to carry on with the investigation without me, let them pack up and go. He refused to come, and they tried to trace him. He could not be traced. So the investigation had to stop. So the organization can relocate the staff from the crime scene, but leave them hanging around, carrying on with some duties, so that they wait for interviewing by the investigation team. Number three, ensure that no one touches computers and the documents in that office or section. What can the investigator do to also assist in the preservation of the crime scene? Number one, avoid touching documents more than it is necessary. And as we have already noted, the investigators are supposed to use gloves when they are collecting documentary evidence and even other evidence that may not be necessarily documents, so that the fingerprints on the items of evidence collected are preserved for further examination. Number two, keep the chain of custody. The principal or the lead investigator is supposed to start keeping the chain of custody from the first minute at the crime scene, so that when he gets the items of evidence, collects them one by one, they are entered in the chain of custody. We are going to discuss what the chain of custody is in details shortly. The role of the investigator in evidence preservation is the main theme of discussion in this section. The following slides will concentrate on that. Let us first define what is evidence. We have mentioned evidence without trying to understand what evidence is. What is evidence? Evidence means many articles, items, or things that can be used to determine the facts associated with a particular matter, or to prove or disapprove a fact in a court of law. For an item or anything to be considered as evidence, it must be able to prove or disapprove a fact in a court of law. Physical evidence need not be visible to the naked eye and can include but is not limited to such evidence as clothing, documents, weapons, fingerprints, footprints, list of passwords, correspondence, etc., that can be compared and analyzed. Evidence can be any other item located at a crime scene. It is advisable that when the investigators arrive at the crime scene, they are supposed to consider any item found at the crime scene as a piece of evidence. All the items should be picked for further forensic analysis. And if after such further forensic analysis, one or two of such items are not found to have any evidential value, then they can be dropped from the list of evidence. Nothing should be ignored at the crime scene. Importantly, any item at a crime scene can be potential evidence, must be picked for further examination. Preservation of evidence. Preservation of evidence means deliberate and specific action taken or cost to be taken with the intention of preventing contamination to, damage to, the loss of, or destruction of, or replacement of any evidence, including the recording, storage, and the maintenance of continuity of such evidence. That is the definition of evidence preservation. In other words, evidence preservation is the process that ensures that the item that was collected from the crime scene is in the same condition and nature when it arrives in a court of law. That is, it has not been contaminated, damaged, lost, replaced, or destroyed. Evidence preservation rules. Evidence preservation rules at the crime scene. If possible, suspects and witnesses should be separated, and the witnesses should be instructed not to discuss the events so as to prevent distortion of facts by suggestion or collusion. The crime scene should not be discussed with witnesses or by standards or anyone that is not directly involved in the investigation process. And continued. Forensic investigators should listen attentively to what is being said at the crime scene, not to shut computers down procedurally. The hard shutdown of computers is recommended. The investigators are, however, allowed to discuss the crime scene with witnesses during interviews. Offices which are considered as crime scene or cabinets with potential evidential documents should be closed. Backup or computer data immediately. Pick all items found or in the desks and drawers of the suspects and keep them for examination. Do not allow non-investigating staff or professionals into the crime scene. Lock your working room and keep the key. Let us now move to the discussion on the chain of custody, COC. What is the chain of custody? The chain of custody, COC, in the context of forensic investigation, refers to the chronological documentation or a paper trail showing the seizure, custody, control, transfer, analysis, and the disposition of physical or electronic evidence. Do expect that all evidence will end up in a court of law. A chain of custody is the process of validating how any kind of evidence has been gathered, tracked, protected on its way to a court of law. A sloppy or non-existent chain of custody may end up being enough for a simple internal investigation of an employee, but it might not be sufficient for presentation to a court of law. And in fact, it is a sloppiness or its absence may bring the integrity of your experts into question. Let us continue with the chain of custody. But it is better for a forensic investigator to keep a habit of always keeping a clear, systematic chain of custody for any investigation, whether it is internal or external investigation. As we mentioned earlier, the investigator must always keep in mind that the investigation and the final report issued will end up in a court of law. Whether the organization which hired the investigation team like it or not. So the investigator should not listen to the client that I want the investigation for internal disciplinary action only, but carry out the investigation according to the best practices. Keep everything as though you are doing that work for the courts, because that report will end up in a court of law. This is how it will end up in the court of law without the willingness of the organization. If your report leads to or causes summary dismissal or termination of service of the suspects, then and the suspects consider that the internal disciplinary process was not fair, they will go to court for to demand that they be reinstated. They will go to court for wrongful dismissal. And what will the organization have as evidence to defend themselves is your report. They will have to take it to court. They will be summoned and be ordered to take that report to court. And that is how the report will end up in a court of law without the willingness of the organization. Or the organization may find that after submission of the final report, they may find that the evidence provided by you as the lead investigator is overwhelming, and therefore they will change mind and hand over the suspect to the prosecution agencies. You will not go anywhere to defend yourself that you did the investigation having in mind that the organization was not going to hand over the report to the prosecution process. Nowhere. You will know nowhere to defend yourself. And you'll be summoned to go and stand in the witness stand as an expert to testify on the investigation and the report you did and your findings. If the investigation was shoddy and you did not keep a systematic chain of custody, then you are going to be in trouble in the court of law. Deal with everything as if it will go to litigation. Investigation is not a joke, it is a legal process. We have already stated that investigation is a legal process. So whatever name it is given to the investigation, sometimes when the internal investigators are called upon by senior management to carry out an investigation, they are told to do special audit. What is special audit? Special audit is an investigation, and you should know that from today, that special audit is an investigation that must be done according to the principles and the best practices in investigation. You keep the chain of custody, you do everything according to law, so that when your report is handed over to a court of law, you will not have to defend yourself against a shoddy job done, but you will be testifying on your well done job, a job well done by yourself in court of law. Don't wait until you have the evidence to make a plan for protecting it. When we were discussing the planning stage, we said that the chain of custody was one of the resources that was to be secured, put in place even before the investigation started, so that as soon as you start the evidence, the investigation, correcting the first piece of evidence, you enter it on the chain of custody. Prove the chain of custody. To prove the chain of custody, you will need a record that details how the evidence was handled every step of the way. The chain of custody will answer the following questions and therefore lend credibility and reliability to the evidential documents or items gathered. These are the questions the chain of custody is meant to answer. What is the name of the evidential item? Is it a forged check? A fake invoice raised and then payment was done against it? What is it? That the exact name of that kind of evidence must be indicated in the chain of custody. How did you get it? How did you get the evidence? How did you get the item? You must be reminded here that any item of evidence are corrected through illegal means will not be admitted as an expert. When correcting or gathering your evidential items, you must follow the law. If you obtain if you, for example, you steal an item of evidence and it is proved beyond reasonable doubt in a court of law that you stole the evidence, then that item will not be admissible in a court of law. That is why there are search warrants. That is why there are court orders. That is why there are subpoenas. So if you must get a document which is in the hands of someone, you need not steal it. You need to get it through a legal process. Get a court order or a subpoena to compel the person to hand over the piece of evidence, and then you'll be okay. When was it corrected? The date when the item was corrected must be indicated in the chain of custody. Who has handled it? Who has handled it? Why did that person handle that item of evidence? Where has it traveled? And where was it ultimately stored? So the chain of custody must track the document from the time it is corrected to the time it arrives in a court of law. You must indicate where it was corrected from, how it was corrected, to whom it was corrected, how it was corrected, who handled it, for what purpose. If it was for fingerprints analysis, you have to indicate in the chain of custody that John took the item on this date, and the purpose why he had the reason why he took it, it was for fingerprints analysis. And after the analysis, he brought it back to the person who corrected it, or the person responsible for its safekeeping, with the report, the fingerprints analysis report. On the date must be indicated when he brought it back, so that the chain of custody does not appear to be broken. You can have a chain of custody, but if any brokenness, any disruption in the movement of that item, then will cause that item to be considered as contaminated, and it might not be accepted in a court of law. It will be questioned in the court of law. Let us now move to the challenges in gathering evidence. Challenges in gathering evidence. The following are the challenges in gathering evidence. Number one, searching employees' offices, drawers, and cabinets. In the absence of the investigation, internal investigations policy, which we discussed when we were discussing the 20 anti-fraud and corruption strategies, we repose a lot of problem. Many of us do not know that a staff who has been given a cabinet with keys, and is the only person who holds the keys, he has been given a desk with drawers, lockable drawers, and is the only person who holds the keys to the drawers. A staff who has been given an office, and that office is lockable, and is the person who holds the keys, keeps the keys. That person has got an expectation of privacy. Expectation of privacy. He expects that none, including his supervisor, will go enter his office without his permission and take items from his drawers, cabinets, and other places in the office. If you break into such office, break into the drawers, break into the cabinets without consent, express consent from the staff, you will be in for invasion of privacy of that staff. So in the absence of the internal investigations policy, which we short of give the employer a blanket consent to break into the offices, the drawers, the cabinets, in case of any incident of fraud and corruption, then you'll be in trouble. But if you have that policy in place, and all staff have signed that in the case of any incident, and the staff is, for example, on leave or has absconded, then the employer has got the right to break into the offices, the drawers, and the cabinets and carry out the search. Then, if there is such a policy in place, then there is no expectation of privacy, and therefore the employee who signed that policy will not come back to claim that the employer, by breaking into his office drawers and cabinets, invaded his privacy, because he had given consent by signing the internal investigations policy, which in one of these clauses gave the employer unlimited rights to the offices, the drawers, the laptops, the communication gadgets like smartphones, if they are issued to staff by the employer. So you have that wide open consent to break into, to confiscate items for further forensic analysis. That is why the internal investigation policy is very important for organizations that are serious in fighting fraud and corruption, especially in large organizations and the government. Number two, searching the suspect's home or house. You cannot just follow your employee to his home or house to go and search for fake invoices, forged checks. You can't do that. He has the expectation of privacy of his home or house. You cannot do that without a court order. And a court order, to get a court order, you have to apply to the court and convince them that you have enough reasons for asking for that court order to go and search the home of that suspect or the house, with powers to break into everything and everywhere in that home in search of the particular pieces of evidence listed on the court order. Another challenge, that is challenge number 3, is getting bank transactions information from his or her bankers. I remember one case we were doing of a very extensive fraud and corruption in an insurance company. And when the investigation led us to the bank accounts, and our hiring authority, the charity of that insurance company, was one of the signatories, and we wanted to get the bank statements to check through and see the transactions, analyze the transactions, who signed, and then trace the amount with the drone to the books of accounts, to try and trace how the amount was spent. And when we went to the chairperson, she was already. She became very, very much suspicious and asked us to stop the investigation. And therefore, we were so much limited because we needed the bank statements to carry on with the investigation. She stopped us from continuing with the investigation. And remember, she was the person who hired us to carry out the investigation. I think she never suspected that we will go that far. And we had to stop the investigation. I later on learned from the staff that the chairperson was the main perpetrator of the fraud and corruption that was taking place in the insurance company. And she had called in for a forensic investigation just for a cover up. And she thought we were to do the cover up. We said no. When she asked us to do a report without examining the bank statements, we said no. We have to stop there and then we leave the investigation hanging. That is what we did and indicated in the report that we were not permitted by the authorities to access the bank statements. That is not the only challenge. Another challenge is that you can be given a go ahead by the organization to get the bank statements, but the banks, because of secrecy, their secrecy policies, they might not readily give you the bank statements. Number 4, recording and listening into the phone conversations of the suspect at the place of work. This is another challenge, because to do this, in most jurisdictions, you must get a court order, permission from the court, because this will lead to invasion of one's privacy as far as communication is concerned. And therefore, you need permission from the court in form of court order for you to sort of tap into the suspect's conversation, record it, analyze it, and then get to know the person is talking to, and then trace the same people, the same to assist in the investigation. It is a challenge. You have to apply to the court for court order, give reasons why you feel that the suspect's phone communication should be tapped. That is the match I had on documents examination as step number 4. Number 5. Step number 5 of the investigation process is documents, evidence gathering, analysis, and examination. And it is very deep, but for the purposes of this training, I wanted to do an introduction. This is and this is what I've done, and this is the end of the lecture. I can see that there is no question, or I can give a minute or two for a question or a comment before I hang up. I've taken about 50 minutes explaining the few slides. So I need, I will wait for a question or a comment before I hang up. There are no questions and therefore there are no answers. No comments and therefore no comments from me also. So I hang up until tomorrow morning at 7 a.m. when I will run through step number 6. Step number 6 of the investigation process. I will go through step number 6 tomorrow at 7 a.m. Thank you very much and bye-bye. Enjoy your night.